Take a second to think about how much your life depends on the internet. All these activities are vulnerable to cybercriminals and malicious state actors who seek their own economic or political gains. Differences in regulatory, institutional, and human capacities between countries make it easier for them to operate across borders. To protect openness and stability in cyberspace, we need to strengthen our capacities and close the accountability gap.
I am delighted to welcome you virtually on this busty day for this roundtable on closing the international law gap. My name is François Delerue. I am a researcher on international law and cyber defense at IRSEM, the Institute for Strategic Research of the French Ministry of Defense, and lecturer at Sciences Po Paris. International law matters in the real world, but if and how it matters in the cyber world is an open question. Does international law matter in cyberspace? That is the question behind this roundtable. International law has become a central matter in the international discussion on state responsible behavior in cyberspace, as well as in state strategies. Yet, only a very limited number of states have disclosed publicly a substantive view or expression on how the rules and principles of international law applies in cyberspace. Similarly, some states have developed the practice of attributing cyber operations to other states and other actors, but the vast majority of the these attributing statements to other states do not make reference to international law. Moving away from state-sponsored cyber operation, international law is also central in addressing the challenges arising with transnational cybercrime. The adoption of the Budapest Convention in 2001 marked a milestone in this perspective as the first international legal instrument on that matter. The purpose of this session is to look at the ongoing initiative undertaken by both research and policy communities to answer this question. Does international law matter, and how can we close the existing gap linked to its application in cyberspace? We have gathered a highly renowned panel to discuss this question. Michael Schmitt, who is Francis Lieber Distinguished Scholar at West Point Lieber Institute, is also Professor of International Law at the University of Reading in the United Kingdom. You have both an extensive experience as a scholar and practitioner since you served in the US Air Force as a judge. You were the editor of both editions of the Tallinn Manual on the international law applicable to cyber operations, and you are also closely working with several states and international law capacity building. Tanya Jančárková, you are currently a researcher at the law branch of the NATO Cooperative Cyber Defense Center of Excellence, NATO CCDCOE, where you work on various projects, including the Cyber Law Toolkit project. Previously, you were a legal advisor and the head of the International Organization on Law Unit at the National Cyber and Information Security Agency of the Czech Republic. Duncan, Hollis, you are professor of law at Temple University Law School in Philadelphia. You were attorney advisor at the US Department of State. You have been working a lot on cyber international law as well as on treaty law, which are closely related topic today. That's make it very interesting in your scholarship. And you were recently elected by the General Assembly of the Organization of American States at the Amateur American Juridical Committee as a rapporteur on the international law applicable to cyber operation. Cathrin Bauer-Bulst, you are head of unit for the fight against cybercrime and child sexual abuse in the DG Migration and Home Affairs of the European Union. You are also co-chair of the Informal Task Force on Electronic Evidence of the European Commission and the Governmental Advisory Committee Working Group on Public Safety Issue within the ICANN. And finally, our last speaker will be Nguyen, who is Associate Researcher at the Institute of Strategic Studies of the Diplomatic Academy of Vietnam. Thank you very much all for joining us today for this discussion. We will start with Michael Schmitt. Thank you very much.
Merci bien, François. Good morning, everyone from the East Coast of the United States, where it is still very early. What I've been asked to talk about this morning is some cyber law capacity building that I've been involved in over the past few years. That's really an effort to bridge this gap. Now, cyber law capacity building really didn't begin until about 2012, as we were finishing up the first Tallinn manual under the auspices of the organization where Tatiana works, the NATO Cooperative Cyber Defense Center of Excellence. The focus of those first questions, because it was a NATO Center of Excellence, was of course use of force and self-defense and international humanitarian law, and primarily for the allies in NATO and for Partnership for Peace states, PFP states. But today, capacity building is completely different. It's run by states and regional organizations, and the greatest emphasis, and I'll talk about it in just a moment, the greatest emphasis is on the peacetime legal regime. Well, I think what's really clear is capacity building in this field is taken off. It was highlighted by the Council of the European Union in 2015, which felt that it was necessary to do capacity building in non-member countries in order to serve as a strategic building block. That's what the council said, a strategic building block for the evolving EU cyber diplomacy effort. And in fact, in all three of the reports at the GGE, capacity building was a point of emphasis. And in 2015, the GGE urged states to begin to offer more assistance and training to developing countries, in particular in the legal field. The GGE also said something which tracks with our experience in capacity building, and that's that it's not just a transfer from developed to developing states, but really all states can learn from each other, and that's been our experience as well. The OEWG, of course, has talked a lot about capacity building. The EU general statement in the first session mentioned the three normative pillars. You have international law, you have voluntary non-binding norms of responsible state behavior, and then you've got CBMs, confidence building measures. And it's been my experience that we need to do capacity building in all of those. So the reason they invited me is to talk about what's been done so far. The first point is, why are countries engaging in capacity building in other countries? I think the clearest statement, the most honest statement that we've seen on this came in the Australian International Cyber Engagement Strategy, which was put out in 2017 and then updated in 2019 with international law. The Australians told us that capacity building is important because you want to build a collective capacity of states to respond to cyber incidents, also cyber operations. You wanted to also make sure that when you're messaging to potential adversaries, that messaging is consistent in order to strengthen the power of the messaging to potential adversaries. And then the Australians told us, listen, we need to empower states to participate in international discussions. Doesn't make a lot of sense to have an international discussion if folks don't fully understand what you're talking about. So the Australians have a very robust program called the Cyber Cooperation Program. Other states have done so as well, have developed these programs as well. Standout state is the Netherlands with its Hague process. And in fact, the Netherlands was the very first state to begin to do capacity building outside the NATO CCD COE. So what's going on right now? There are three big players in this field: Netherlands, the Ministry of Foreign Affairs, Singapore, and its cybersecurity agency, and Australia, the Department of Foreign Affairs and Trade, or DFAT. A number of other countries have played a role: the US, Germany, Canada, the United Kingdom, New Zealand. There's one other big player on the horizon. We can't talk about it yet because we're still chatting with that country, but we'll have another big player, so there will be a big four in this field. And they all work with a group called Cyber Law International, which consists of a number of Tallinn Manual alumni who spent 7 years working in this field, so they're pretty good. Now, how does capacity building work? Well, it works on 3 levels. First, there are national courses. So yesterday, for example, I finished doing a 6-day course for Indonesian officials that was sponsored by DFAT, by the Australians. And I will move into courses for Vietnam by the Netherlands, and Australia will do a course in Malaysia. The benefit here is we're bringing together people from across government who may not have met each other to collaboratively address the problems that we discuss, facilitates national positions, rules of engagement, development of strategies, and so forth. The most common format, though, has been regional. This was something that was the need for which was emphasized by the GG in 2015. Here we've worked in 3 areas: the Organization of American States. My friend Duncan will talk about that in a bit. We'll do 3 courses in the OAS space this year. We do courses in the ASEAN space, Association of Southeast Asian Nations. They're always based in Singapore, unless it's virtual. We'll do 3 there this year. And we will do 2 courses for the OSCE, Organization for Security and Cooperation, in Europe. We run those in Vienna. That's for Balkans, the Stans, Eastern Europe, and so forth. And we will run 1 international global course sponsored by the Germans and the Americans at the Marshall Center in Germany. A very interesting course because the perspectives are so very different. What we found is that in order to do this effectively, you really have to cover all the topics from soup to nuts. And the reason is because the topics are so interrelated. So if you're talking about sovereignty, for example, you can't really do that without talking about diplomatic law. Or if you're talking about sovereignty, it's tough to do that without talking about the law of the sea because of naval empowered missions. So we talk in these courses everything from sovereignty and intervention, due diligence, to use of force, human rights, domains. We talk about space law, diplomatic law, on and on. And it's particularly effective because the University of Reading, a British university, certifies these courses. And so that brings a lot of people to the courses on the basis that they want to get credit for their professional advancement. There are also bespoke courses. 2 weeks ago, we did a course for the Women in Cyber Fellowship Program, sponsored by Australia, Canada, New Zealand, the UK, and Netherlands. These are folks who are going to be working in the OEWG or have been working there. We're building a human rights course for Australia. So there are lots of bespoke activities as well. Finally, let me finish up and tell you what we're finding out there. We're finding that a lot of folks don't really understand how international law applies with the requisite granularity. And that's pretty problematic because we're working with decision makers, legal advisors, and operators. And listen, if these folks don't know the rules of the game, then it really is a wild west. We're finding that there is a persistent myth that cyberspace is that wild west, a lawless void. And that's problematic because that means states will begin to work from a standing start. In fact, there's plenty of existing law that applies. The trick is figuring out how it applies in the cyber context. We're finding that there are superbly talented folks all over the world, and we would like to work with them so we could build cyber leadership within their country. We find that states don't like to be pushed around. That should come as no surprise. States want to come to their own conclusions as to their own normative environment, conclusions as to how they are going to interpret existing international law and look to new international law. They feel vulnerable to exploitation, especially by big powers. And so they want to be empowered to operate, to negotiate from a stand of sovereign equality. And so finally, the question is any of this successful, or is this just throwing money and effort at a perceived problem? I really, over the years that we've been doing this from 2012, I believe that the sophistication of folks in the field has been growing exponentially. So in Indonesia, for example, last week, we talked at a level that would have been unthinkable in 2012. So at least this seems to be getting a little bit of traction, although diplomats and so forth will have to tell us how that's working out in the GGE, open-ended working group, and so forth. And with that, I think my time's up, François.
Indeed, thank you very much. That was very interesting and like connecting a lot of different questions. I think one of the very important comments you made is actually this point that the rules are out there. So we have a lot of rules and principles of international law that may apply, but one of the issue is the fact that the people who have to apply them may not be aware of them, or maybe they don't know how to apply them. I think that's a very, that was a very important comment. I will now pass the microphone to the next speaker, Tanya Jančárková. So, your turn.
Hello, thank you very much. I hope the microphone will work this time. Thanks very much for the floor, François. And I apologize if I won't be as eloquent as Mike has been, because I haven't spoken to many more people beyond my family and immediate colleagues over those past few months. So yes, I worked at CCDCOE Law Branch, and as such, I'm part of the team behind the Cyber Law Toolkit. If you type in cyberlaw.ccdcoe.org, you will find a hopefully dynamic and interactive online tool, a wiki-style website, which is based on scenarios, on case studies, which combine facts and legal analysis from the perspective of public international law. And why we are doing this project jointly with Mike's former employer, University of Exeter, my home agency, the Czech Republic, and CCDCOE, and later on also ICRC and Wuhan University, is because we perceived a gap between academia and practice. Very often, there's quite a lot of research in public international law field on cyberspace. So clearly, international law does matter. Which was the question of this panel. It does matter, but many people are unsure how to apply it indeed. And we have found with my colleagues that the research findings are often a little too theoretical, maybe a little too stretched beyond their practical applicability to be relied on as a source of lex lata. They may be not as specific as the practitioners would have liked, when they face a situation and they are looking for an answer to what do I do now? What can my adversaries do? Question, and this type of question. So we aimed at offering a one-stop shop, let's say, that would offer an opportunity and a possibility a possibility to access international law in a comprehensible and friendly manner, let's say. It's aimed obviously at legal advisors primarily, but at the same time it should be comprehensible for non-legal people, as policymakers, policy officers and stuff. And we would hopefully also offer the academics a view out of their ivory tower and see what a practical situation can look like in a situation of cyber incident. So you will find at the moment 14 scenarios. Maybe some of you will be familiar with the cyber defense exercise that CCDCOE organizes, Locked Shields. So you can think of the toolkit as a simplified version of Locked Shields, or the legal game of Locked Shields, let's say. So you have a case at hand, a situation, hypothetical situation, but based on real life examples. And you are faced with questions as a legal advisor, and you need to find a solution. Maybe you have to provide an operational, let's say, guidance from the perspective of public international law. So that's why we provide a step-by-step legal analysis, providing references to the existing research, to the existing literature, but also to publicly made statements, because this is another issue. There's a lot of research, and although there's not as much publicly available information on state positions as yet, it is growing. The amount of information available is growing. So it might be difficult sometimes to navigate in the amount of information available and making it making it usable for your own needs. And this is why we're here, basically. And so at the moment, we have 14 scenarios, and we are preparing 5 more to be published this September. And the topics span from critical information infrastructure protection to humanitarian law in military operations in cyberspace. The new scenarios, I think my colleagues won't object if I provide a sneak view. We will be dealing with collective responses by states, which is quite a hot topic now. We'll be dealing with targeting of cyber operators from the perspective of humanitarian law. And we will also delve into naval law, which is a new domain and probably not one that will immediately come into one's mind if we talk cyber law. So what we are trying, to answer the question of this panel, if international law matters, it does, obviously. How to apply it, that's the question, and how to bridge the gap, or what are the gaps that we perceive? Is the gap between the different users, let's say, of international law, and the different groups that are affected by international law, and they need to orientate themselves in international law. And this is I think what we should be aiming to do. It's not only about state officials and teaching them about international law, but also closing or bridging the gap between the academia and the practitioners, for instance. And I might be getting closer to my time, so I think I will leave it here.
Thank you very much for this presentation. It's indeed a very useful tool. I have been using it a lot for my courses, actually, I have to say, at the university, and I highly recommend to check it. And yes, that's an important question, is we have a lot of work made by academics who are producing commentaries, who are producing like literature on the matter. But one of the issues is how you translate it and how you translate all these theories, all these questions into practice. And I think this is a very interesting aspect of your project, is it's offering concrete example how all these questions actually may apply and may play into real cases or fictional cases. So yeah. I will now give the floor to the next speaker, Duncan Hollis.
Thank you, François, and thanks for the opportunity to speak. As you noted, I wear a bunch of different hats in addition to being a professor. I should also add that I consult regularly for Microsoft. I think it's important to disclose that. But I'm speaking today in my capacity as a member of the Inter-American Juridical Committee. The Juridical Committee is actually one of the principal organs of the Organization of American States, and we're comprised of 11 international lawyers from across the region. And we serve in our individual capacity and try to advance rule of law topics, whether at our own initiative or at the invitation of the General Assembly. Since 2018, I've served as the rapporteur of a project entitled Improving Transparency, International Law and State Cyber Operations. To date, I've produced 4 reports. I'm currently trying to finish a 5th that I'll be presenting next month. I'm going to try and share a link to my latest report for anyone who's interested. The project starts with a basic premise that we need to understand how international law applies by asking states for their views, and that the views of states are not exclusively to be sourced to the highly developed, high-capacity Western states who've been most detailed in their expressions so far. Similarly, we don't think it's necessarily an exclusively a UN process, particularly not one just situated in the first committee, with its totally appropriate focus on international peace and security, but there needs to be recognition that there are a lot of international law issues that extend beyond international peace and security. The project's goal is kind of threefold. First is to try and identify from member states areas of convergence. Where is there an overlap in views? Where are there shared understandings of how international law applies, or even what specific regimes apply? Second, we're quite open that we're looking to identify areas of divergence. That is, where do states disagree? And that can be a good baseline for future dialogue, for reconciling divergent views, or perhaps even clarification. And I think, as Mike hinted in his talks, identifying these divergent views is also important to avoid, the perennial risk of inadvertent conflict, escalation, where states are operating on different baselines or different understandings. And third, I think, frankly, the goal is to look to instantiate the OAS and its member states into the global conversation and elevate its members' voices. To date, the project's had kind of two different approaches. First, we've sought to have a questionnaire. We formally, through the OAS Department of International Law, asked member states, what do they think about international law's application in cyberspace? And second, I hosted a kind of a Chatham House style conversation among member state foreign ministry, both their ambassadors and their legal representatives from their foreign ministries. The questionnaire canvassed member states on 10 of the most pressing international law issues, including, the basic question of which international law regimes do you agree apply or don't apply, also the prohibition of the use of force and self-defense, state responsibility, particularly for non-state actor behavior, international humanitarian law, sovereignty, and due diligence. To date, we've received responses from Bolivia, Chile, Costa Rica, Ecuador, Guatemala, Guyana, and Peru, with the United States kindly forwarding along their previous public statements, while Brazil kind of indicated that it would be answering these sorts of questions in the GGE context. Obviously, 8 states is a minority of the OAS member states, but I do think that the responses to date reveal some key takeaways. First, the responding states agree with the global consensus that international law applies to cyberspace, but they do reveal kind of continuing equivocation and even disagreement over the particularities. I'd note 2 states, Guyana and Guatemala, suggested the novelty of cyberspace may make the application of existing international law difficult. Second, in the context of international humanitarian law, Chile, Peru, and the United States agreed that a cyber operation could not constitute an attack if it fails to cause death, injury, or direct physical harm. In contrast, Guatemala and Ecuador responded positively to the idea of delimiting attacks based on, just the loss of functionality in computer systems. Third, on the big sovereignty question, Bolivia, Guatemala, Guyana clearly articulated sovereignty as a standalone, independent rule that impacts cyber operations. States like Peru and Ecuador were more equivocal, with Chile and the United States hinting at the possibility that sovereignty only operates as a principle. They didn't, come out and state that was an official view, but that was kind of the way they answered the question. Fourth, I think a majority of responding states, including Chile, Ecuador, Guatemala, Guyana, and Peru, accept the idea of due diligence as a legal rule in cyberspace. Bolivia was a bit more equivocal, and statements outside the OAS suggest that the United States is reluctant to concede due diligence as anything more than a voluntary norm of responsible state behavior. Still, I think I at least was a little bit concerned that 8 of 34 responding states suggested we might need to tackle this process in a different way. So this spring, with the OAS Department of International Law, we hosted kind of a Chatham House style conversation for several hours, almost 3 as a matter of fact, among 16 ambassadors and foreign ministry legal advisors, as well as a representative of the ICRC. And I think that conversation and the questionnaire responses suggest kind of 2 broader themes here, that many states are currently reluctant to be transparent about how international law applies, right? They're reluctant to come out and say, that there is a gap, there isn't a gap, they're reluctant to opine. Why they're reluctant, I think, varies. Clearly, some of it is political. Some states are wary of getting involved in a space where you have major states like the US, Russia, or China, that if they express themselves, they kind of put they mark themselves as getting drawn into politics that they wish to avoid. Other states may wish to avoid limiting their maneuverability. They may not want to come out with a position lest it affect their own ability to operate in some future case. And third, I think there's also internal politics. Some states are still trying to coordinate internally where authority and capacity lies for cyber operations, both offensively and responding to cyber threats, and that may limit their ability to speak publicly. For other states, though, and this I think ties to what the 2 previous speakers said, I think it's not a political issue, it's a legal issue, that there is in fact not a substantive issue, but a research-driven one, that there's a lack of staffing or a lack of expertise on these international legal questions, right? That states simply don't yet understand the issues enough to formulate views. And if they can't formulate views, they don't really have anything to be public or transparent about. And so I think it reinforces the idea that we need to do more capacity building, not just in the technical space of getting states up to speed on how ICTs work and the threats they pose, but as Mike and Tatiana both suggested, in that legal space. And I'd note the OAS has been doing this for several years through the CICTE, the Inter-American Committee Against Terrorism. Mike and his organization have done a number, as he suggested, of classes on this. I'd also note, member states can use the online resources that Tatiana mentioned as well. But I do think we need to be thinking about, like, what else could we be doing, right? What other legal capacity building efforts might be useful out there? So we might think, for example, about training lawyers in hacking and coding, right? Technical training for non-technical experts. I think there's a discomfort among lawyers engaging in cyber that we need to address. We could think about more gaming workshops, right? Taking those virtual exercises and putting lawyers, foreign ministry lawyers in a room and having them work through these issues. And I think, frankly, I heard a lot of positive feedback, at least in our region, for more regional dialogue among the lawyers only, right? Like more Chatham House style conversations that are diplomatic exchanges with low stakes and low barriers to entry that can set the foundation for kind of a more unified front against the collective threat of both underregulated or unfettered state cyber operations. I'll close by noting, my own hope is that the OAS experience may hold lessons for other regions and regional bodies. Obviously, if expressed through the proper channels, greater participation by nation states about what they understand international law to mean and how it applies can promote both shared regional visions, but also kind of set up the state practice with opinio juris that will help us both identify and codify customary international law. I certainly think fostering non-European perspectives will inform existing European perspectives and put them in a context that we really need to be thinking about, and ensure the requisite diversity of state voices here. And finally, I'd note this is not an exercise just for international lawyers, right? I think in the end, greater transparency, greater capacity building efforts in the international legal context may promote stability and cooperation for cyberspace overall. So let me just stop there and say, I'm looking forward to any additional conversations or Q&A we can fit in. Thanks.
Thank you very much. Yeah, we have already some question, and I would like to recall people who are listening to us, don't forget to send your questions through the chat so we can address them later. Thank you very much, Duncan. That was very interesting. And yeah, I think it's a very interesting point you made when you say that it's rather a legal issue than a political issue that states are not disclosing their view on how international applies, because there is this capacity building question and the fact that they may not have yet enough understanding and enough expertise on this question. So yeah, that's a very interesting point, and which reflect a lot with previous discussion we had. I will now give the floor to our next speaker, Cathrin.
Yes, thank you very much, François. And if I may, I'm now going to take you away from the larger cybersecurity and capacity building picture and zoom in a little bit to the perspective of international conventions on criminal law. Now we're here to discuss closing the gap. For cyber-enabled crime, the challenge is of a slightly different nature. We already have a number of regional and global international law instruments, but I will explain why that doesn't always facilitate things. Now, first of all, why do we need these instruments? Applying criminal law creates a special challenge in cyberspace. The EU has been of the position for a long time that the same rules that we apply offline also have to apply online. And my team at the European Commission on the fight against cybercrime tries to contribute to that very lofty goal. The key issue that we have seen is one that was already eloquently displayed in the video we saw at the beginning of the panel. How do we close the accountability gap? This goes for conduct that amounts to a crime, and crimes facilitated by cyberspace are activities that result in the interference with computer systems, hacking, the distribution of illegal content like child sexual abuse materials, but also traditional crimes that were once conducted offline, like drugs trafficking or arms trafficking, that are now facilitated by cyberspace. And the main challenge that we find here is with investigations. Our authorities need effective and efficient measures for their investigations, particularly to obtain access to electronic evidence, and that is increasingly stored on servers in other countries. Now, while for the companies operating those servers and also for criminals, the internet is more or less free of borders, as was also shown in the video. The same, of course, is not true for law enforcement, whose competence ends at the national border or sometimes even at regional borders. Investigations, however, in cyberspace all raise significant issues of a cross-border nature. For one side, on the criminal law side, what is considered illegal in country A may not be considered illegal in country B, or what authorities can do in terms of investigative actions under the criminal procedural law framework in one country may not be allowed in another country. Now, this vastly complicates the work of authorities and has given criminals a great head start. So there's a key role for international law here. We need to agree between countries what our authorities can do and how we can investigate and prosecute cyber-enabled crime, because if we stop at national borders, we're not going to get very far. In the EU, we've been working on a number of initiatives to make the work of our authorities in such cross-border situations easier. We've harmonized the data protection acquis. We're also harmonizing definitions of offenses and safeguards, and we are harmonizing investigative measures. An important recent initiative here is the Commission's proposals on cross-border access to e-evidence, which would allow authorities in one member state to access data held by companies in another member state, for example, to identify who is behind an IP address used in a cybercrime. But of course, we need to look beyond the European Union. The internet knows no borders, not at the national, but also not at the regional level. And this is an international problem. We saw during a survey just this past February that 177 of the UN member states, that's a full 92%, were undertaking reforms of legislation on cybercrime and electronic evidence, or had just concluded such reforms in recent years. So this is an international problem. And the Budapest Convention on Cybercrime that François mentioned in his introduction is indeed crucial in this regard. It's become the main multilateral framework for the fight against cybercrime to facilitate cooperation between authorities of its state parties. Now, the Budapest Convention dates back to 2001, and the negotiations even started back in the dark ages of the internet in the 1990s. But it's still relevant today. It's a Council of Europe convention that is open to non-Council of Europe member countries, and it currently has 65 parties and continues to grow. Now, Mike and Tatiana already mentioned the key importance of capacity building, as did Duncan, and that's true here as well, because rules, of course, are only helpful when people know about them and can apply them in practice. And the advantage here of the Budapest Convention is that it is more than just a legal text. Joining the Budapest Convention implies a more universal, comprehensive commitment. The convention has provided long-term outreach amongst the parties and also beyond, especially through comprehensive EU-funded Council of Europe technical assistance and capacity building programs. And these efforts in technical assistance and capacity building have brought about substantial advancements in terms of harmonization of domestic legislations in the states parties to the Budapest Convention, the exchange of best practices and expertise, enhanced cooperation and coordination with international partners. It has also provided a standard, even for countries who are not members yet of the Budapest Convention, to measure their national laws against and to possibly consider using as a model for new national legislation. And in that way, we have helped parties through capacity building to up their game. And we've also helped other countries interested to join to level up to the requirements of joining the Budapest Convention. And I hope that in the chat, you will see a link to the main page of the Council of Europe that details the capacity building efforts. And we see the importance of capacity building also in closing the legal gap as the previous speakers have already mentioned. Capacity building can help foster regulatory convergence to a higher level, where we can cooperate effectively and be more successful in tackling borderless cyber-enabled crime. And as Duncan already highlighted, we also need to empower all countries to contribute to the discussion and to be involved in shaping international norms. And that empowerment also requires capacity building. Now it's not all rainbows and stars for the Budapest Convention. At the same time, this convergence also brings about its own challenges. Remember, the convention was adopted back in 2001. And as technology and markets and criminal methods have vastly evolved since then, the states parties are currently working to update the rules, notably to improve cross-border access to evidence for criminal investigations. A lack of compatible rules at international level creates a very challenging situation, not just for authorities, but also for companies, service providers of online services, who may be faced with conflicts of laws when it comes to respecting their obligations under different regional or national instruments with overlapping reach. For example, access to data in one country might be prohibited by data protection rules in another country, and the company might be active in both. So it requires us to sit down and come to a joint approach for how to deal with these issues. The EU and the Commission, of course, support the effort of updating the Budapest Convention, and the Commission and my team negotiate on behalf of the EU 27 in this process. Now, these negotiations are by no means easy, considering the diversity of state parties already around the table. They may have different understandings about what constitutes a crime or what constitutes a fundamental right and how to implement protective measures. And sometimes it also requires state parties to reconsider aspects that they typically consider as part of their sovereignty, as that no longer makes sense in an online world. For instance, the storage location of data is actually nowadays an arbitrary choice for providers based on technical considerations such as load balancing and latency, making sure that users have swift access to their data rather than considering national legal regimes. And if a country attaches importance to storage location as an aspect of sovereignty, that creates challenges. So it's difficult, but at the same time, the second additional protocol that we are using to update the Budapest Convention will be crucial. We're hoping to complete the process by the end of this year. The alternative, after all, is not attractive. It would just mean that criminals can operate even more effectively on the internet than our law enforcement authorities, as they already do today. But the progress is also indispensable, and here I come to what I was mentioning in the beginning about the fact that there are several instruments. The progress to update the Budapest Convention is indispensable also in view of the current discussions about negotiating a possible new international legal instrument at the UN level. And we're watching this process with great interest because there are many unknowns about this new process and about the idea of having a competing convention. Apart from the time it will take to negotiate a new treaty, of course, any future international agreement needs to take into account what has already been set out in the Budapest Convention and be legally consistent with that, and also with the important achievements that we have achieved under the Budapest Convention. As I was saying, the majority of the UN member states already have been using the Budapest Convention as a benchmark for reforming or developing national cybercrime laws. So now we need to focus our collective efforts on the bigger challenge, on developing the skills and the capacity to apply cybercrime legislation, on advancing the capacities of law enforcement and judicial authorities, and on improving international cooperation mechanisms. And of course, we must ensure that any new initiatives are guided by the rule of law principles applicable to law enforcement, which include legality, proportionality, necessity, and the respect for human rights. We want to avoid any increasing state control over cyberspace and individuals that might undermine existing human rights and fundamental freedoms. And we need to uphold our commitment to the open internet. So that for us means, again, that we need to include all players, governments, experts, the private sector, civil society, just like we do in this conference. Multilateral cooperation and stakeholder partnerships are at the core of the EU's global engagement on cyber issues, and EU Cyber Direct as a project is just one example of our commitments. It is evidence of exactly the approach we support and that all the previous speakers have highlighted as key. We want open, transparent discussion, we want mutual education so that we can collectively work towards better cooperation and stronger norms. And that's key if we want to close the gap, not just between countries, but also between authorities and criminals.
Okay, thank you very much. Thank you very much for this this very interesting presentation, which was very interesting actually compared to the others and narration with the others, because in some way you are closing also an important gap, the gap between, let's say, state-sponsored cyber operation and the rest, cybercrime and all these questions, which are very interesting because they are very similar in terms of the way they are performed on the technicalities, but then very different in the way they are addressed politically and also from a legal perspective. So that's, I think, a very interesting perspective in our discussion. I will now give the floor to our last speaker, Fu.
Hi. So I think I should send a good afternoon wishes to everyone from Hanoi. So I'd like to focus my intervention on the gap that we perceive from the national level. That might contribute to our discussion. I think the biggest gap we see is the role of private companies in the governance of cyberspace, or more specifically, the tech companies, because somehow we mention about cyberspace or the internet, but actually what we interact daily is actually online platform created and controlled by private companies, and our behaviors online is normally the object of regulation internationally, or international or domestic legislation. But there's not so much for now in public international law or regional law or domestic law to regulate what private company must do in order to enforce the rules. But I think that the issue with private companies, if we approach the internet from their perspective, and we see that there's a problem, or there's somehow a lack of rationale for tech company to take actions in cyberspace, they might consider costs like reputation costs or operation costs to enforce rule written by states or even international community. And that is the biggest gap we see right now, because when we forget their role, then so we somehow follow the traditional approach where international relation would depend on interaction between states, but states do not control cyberspace completely, and we somehow are still stuck in the abstract discussion about how we understand our sovereignty, of our national jurisdiction, how we understand about due diligence, or what would be the attribution rules in cyberspace. International surely applies, but it's still very as the early stage, and somehow we need more time and much more discussion to crystallize the contours of those very fundamental terms and concepts in cyberspace. It may take another 10 years, I guess, or even more. But now we more or less would look at soft laws. I think consensus we have in 2015 is a good start. We have the consensus report of the GGE there. We could start from there. But in addition to that process, we are still looking at the progress as the UN ODC process in Vienna, where we are discussing about a comprehensive study on the issue of cyber crimes with some potential outcome, such as models, clauses on international cooperation or digital evidence, etc. The soft law would not be directly binding on states, but it would provide guidance on UN member states how to write their domestic law. We would regulate their domestic cyberspace. And when we talk about domestic cyberspace, we have to consider this policy of state to somehow to push for digital transformation. I'm not sure about the situation in Europe or South America, or in Africa, but I think in Asia Pacific, digital transformation is like a race where most of governments in South Asia are pushing at the high speed for digital transformation, where they want to digitalize almost everything in daily life. They want every shop to have a digital like an IP address, and they want to create a cashless society. They want everyone to go to banks, open and use the electronic wallets and do all the electronic transaction. So the transformation would create the need for every government to build up their agencies in order to safeguard the functioning and the protection for the infrastructure that may enable that transformation. So from the perceived roles of state in that perspective, we have an issue of cybersecurity and cybercrime, and then from that, state would have to improve their domestic law, and also have to engage in international discussion on how to identify actionable risks and how to minimize them, and what they can do to mitigate perceived risks. So I think like the process like that would require a lot of knowledge on how the cyberspace operates, and what can we do in cyberspace, and what's the difference between the cyberspace and the real world. And then I think that in that perspective, I think the approach by a number of countries like Australia or Netherlands or Singapore on pushing for or investing in capacity building is the right direction. Last year when I attended a conference in Singapore or in Malaysia, when we asked the other ASEAN colleagues like in Myanmar or Laos and Cambodia, then they're still now struggling with the very basic idea how to regulate cyberspace. For example, they did not have a law on digital transactions. For example, they could not have specific law on how company may do business online. So I think like capacity building is very meaningful for many states, so that they may properly regulate their domestic or cyberspace, and up from that, and they may have to enhance the capacity of their law enforcement agencies and other things. And then And with regard to cybercrime, I think it's also very crucial if we look at the cyberspace and behind it, even though when we may talk about armed forces here and there, or we could say, but in the end, it's still somebody, is it like a normal person? Maybe it's not like a normal person, but it's actually everything done in cyberspace must be conducted through a person. So if we have proper criminal provisions to prevent people from doing malicious things in cyberspace, and we could agree on those things, we may stop people from doing bad things at the very early stage of their career, instead of letting them grow into like a super hacker or something. I think I should finish my intervention here. Thank you.
Yes, thank you very much for your presentation. That was also very interesting and giving another perspective on these questions. We are a bit running out of time, so I discussed with the organizer and we'll take 15 more minutes for the question, if it's fine with everybody. So I will now turn to the question, received a lot online. Also, I will ask the panelists to think if they have any comments, reaction, question between them and the other presentations. Maybe I will start with a group of questions that were more or less on the same topic, on the same question, which is on state practice and the view of state. So, why states are not referring to international law in their practice? And the question was relating to this question of attribution. Why, when they are attributing cyber operation, do they don't use international law in their statement and in the way they are attributing? And maybe like building on the comments we had from Duncan, from Michael, on capacity building efforts. Have you seen in that respect an evolution following on the course you are providing, following the experience you have with states in using more, or at least taking into account the rules and principles of international law in state practice? So yeah, that would be grouping first part of question. And then the second part of this question will be related to, let's say, the fragmentation of international law, or the fact that states have different views on how international law apply or what are the rules. As a French, I have to highlight this point. So for example, on the question of sovereignty, where France tend to have a very traditional approach on this question, other states will have other approach on sovereignty. And how do you take it into account in the capacity building efforts? So is it something that is really focusing on one approach, or are you taking the diversity of approach into account? And in the same way, is there not a risk by using scenarios, using this effort to undermine other approaches and to, at the end, just prefer or favor one specific approach over the others? So how do you take into account this different perspective? I don't know who wants to answer this question. Duncan, yeah?
Thanks. Yeah, I saw several other hands move, but maybe mine was too closer to the camera than others, so therefore it was more visible. I think, you know, on the question of why do states not invoke international law as part of their accusations, I think it's an observation that's been made now kind of repeatedly for the last several years. There are some exceptions. So in 2018, when, you know, the Dutch and the British, along with the Australians and the New Zealanders and the Canadians, accused Russia of certain cyber operations targeting WADA and the Organization Prohibition of Chemical Weapons, the OPCW. They did reference the activity as, you know, inconsistent with the rule of law, but the reality is, you're absolutely right. We've not seen states, you know, begin to actually invoke and say, you know, WannaCry was a violation of international law, or election interference, whether in France or the US, was a violation of international law, let alone what particular aspects of international law were violated. I think there again are both kind of political and legal reasons for it. I think, you know, politically, I think if you talk to the people that are involved, they're having just enough trouble making the attribution and formulating the accusation, and they're somewhat reluctant to go the step further to bring international law. So it may be that we're just early on the curve with respect to these sorts of, particularly collective accusations, and that international law may be brought in more down the line. I do think, though, there is some concern about maneuverability, and some states want to say that's bad when you do it, but they don't necessarily want to say it's bad under international law, because that would in some way maybe restrain themselves. I'll note that Martha Finnemore and I have a new article coming out in the European Journal of International Law that tries to think through why we're not seeing international law as part of these accusations, and what the benefits and costs would be of states doing so. In terms of how to account for different views, I think we may all have different perspectives on this. My own sense is that we have to be honest, and we have to acknowledge, there are areas of consensus. Everyone will say that international law applies. It's now become kind of a trite phrase, but it's a really important one for those of us who've been back in this, in the dark ages, as Cathrin said, of the 1990s. And, I was on the delegation that negotiated the Budapest Convention, so I'm feeling old now. I think it's been nice to move beyond the idea that international law is some, lawless, not international law, cyberspace is some lawless void. But we've really struggled to move beyond that generic statement. And so I do think when we work through where states and state practice is, we have to be honest and kind of say, well, a vast majority of states think this, but there are some outliers, or areas where, frankly, it's pretty divergent. And areas where states have been reluctant to speak, I think, is also part of this conversation we have to do. And maybe this is an agenda, not just for states, but others. We have to keep working on what silence means. What is the implications of silence for international law? Is the default that all the other stuff continues to apply, or at some point does silence in the face of some of this activity force us to rethink the rules? But I'll stop there and let others chime in.
Okay, thank you very much. I think Michael wanted to follow up on this question.
Yeah, I guess I would agree with every word Duncan said and then more. I think it's unfortunate that more states have not come out and set forth their positions. But I don't think it's necessarily a problem with regard to capacity building, because if you do capacity building right, when you're teaching a course or when you're doing the Tallinn manual, you work very hard to make sure that all the views are on the table. Because if you don't, your capacity building will be a complete failure. The folks that participate in these programs are extraordinarily sophisticated, and they know when you're trying to pitch a particular view. So when we are doing this for the nations, we'll take sovereignty, which is a big debate. We always set forth the British position that there is no rule of sovereignty, that it's just a principle of law, and then set forth the position of the Netherlands and France and so forth on how sovereignty may be violated. The same with due diligence. Is it a rule or is it a voluntary non-binding norm? So I don't think that poses the slightest problem with regard to capacity building, so long as you're objective. And you can even work that into the scenarios. The scenarios are a wonderful opportunity to highlight these differences. So you create a scenario that raises a question of sovereignty. Not only is it a rule, but where's the threshold for breach? So this is really opportunity. The important thing is that you get folks that are engaged in capacity building that don't believe capacity building is for the purpose of advancing their own narrow national interest, but rather developing capacity so there can be a mature discussion. So in the programs that I'm involved with, not once have the Dutch or the Australians, Singapore, the United States, not once has one country said, Mike, pitch this view or another. Moreover, we work with pretty serious academics, Marko Milanovic, Dapo Akande, and so forth. And even though they have strong views, and I may have occasionally a strong view, we absolutely forbid them from pitching their view without offering up the countervailing position. So I think that's a perceived problem that, if you do it right, is not a problem in capacity building.
Okay, thank you very much. Tanya, you wanted to,
Yeah, I just wanted to add my 2 cents to this debate. we have had, for instance, in the past, had comments that we may rely too heavily on Tallinn manual, for instance, but we in the toolkit scenarios. But this is a useful exercise. That's why we also make our scenarios go through an external peer review from various people, let's say, and we always make an effort to reflect the differences in the debate. For instance, on sovereignty, we always provide references and at least outline the different views of different states on sovereignty. So it should never we never aim to provide a definite answer in our legal analysis. So I agree with Duncan and with Mike that the differences in interpretation are not necessarily a problem.
Okay, thank you very much. Any other reaction on this question? Okay, I will move now to another question or another group of questions, starting with how can we bridge the gap between criminal law conversations and the international law discussion when it comes to accountability of non-state actors? I think it's a very important question, and also that may be grouped with another question when someone asked, how can the non-state actor be part of this conversation? And this conversation, the conversation about peace and security in cyberspace, but also cybercrime. I would also ask you here, what are your views about the UN third committee process on a new cybercrime instrument? What are the main questions? How we can use what is in place, or how what is in place will be used? I think about the Budapest Convention, and will it constitute a good starting point, or do you think that it will take a different direction maybe, or what's going on? So, who wants to go on this question? Cathrin? Yeah.
Yes, I can start. I mean, that's a whole bunch of questions grouped into one. Let me start with accountability. I mean, one central issue for us here from the criminal law perspective is the basic whodunit. Who's behind the act that may constitute a crime? And I think here we already see that in capacity building efforts, we can take a joint approach. It doesn't have to be crime specific, because cybersecurity researchers, professionals, cybersecurity authorities are faced with the same forensic needs and requirements that we have in criminal law investigations. And we actually already have examples of projects that we have funded where the question of forensic attribution has been taught in courses that were targeted both at the military and at law enforcement, to enable them to basically apply the same kinds of tools and procedures to identify who might be behind an action. Now, where the paths start to diverge is when it comes to the legal requirements for attribution, because after all, when you look at criminal law, you're looking at sanctions against people that are severe infringements of their individual personal freedoms, down to sanctions of imprisonment. And there we have a much higher standard of proof when it comes to linking a person to an action, then we might need to take certain defensive actions in cybersecurity from the perspective of a private company. And then again, the question is when it's not an individual privately acting as a cyber criminal, what level of attribution is required to be able to deploy diplomatic tools? And that's already been mentioned by others here, where again, I don't think at the present moment, and previous examples cited show this, we don't have a universal agreement of what it takes to make that attribution. So that's my 2 cents on that part. When it comes to the question about the third committee in the UN, I think in these discussions on the possibility to negotiate a new cybercrime convention under the auspices of the UN, many very basic questions remain open that we need to tackle in the committees related to the basic procedural requirements. What procedure will we apply for the negotiations? Will we work on a majority basis or consensus based, as we've done previously in the UN ODC procedures? What role will we attribute to the existing processes on capacity building that we have already launched under the UN ODC? And how will we integrate civil society and academia into the discussions? I think those are just a few of the big questions that we still have to tackle. there will be a first meeting in August where possible states interested in joining the discussions will discuss these and other procedural questions with a view to bringing a first set of proposals for a new resolution to the UN General Assembly later on this fall.
Thank you very much. Someone else wanted to jump in? Okay, Duncan.
Yeah, just quickly on those questions and echoing Cathrin on the question about private companies getting more part of this legal capacity building. I fully agree. I think the reality is the tech platforms, social media, they need to understand international law as well as states because of their role in the space, in much the same way that we've seen in other areas in the environment or labor. Multinational corporations and others have to understand what the international law implications of their products and technology are. On the treaty question, I'm again feeling old, but I've been on the treaty train for a while. While I think international law applies, I question how effective and sufficient it is. And so, I've been suggesting there is maybe a need for a treaty conversation. But I'm a little frustrated by the current UN dialogue, which is either that we need no treaty, or we need a treaty that protects states from people, right? We need a treaty like a Budapest Cybercrime Convention. But I think there's a third possibility, which is that we need a treaty that protects people from states, right? That state cyber operations have these humanitarian impacts. And so, I'd love to see the conversation evolve a little bit to more, if we're gonna have a treaty, is it about protecting people from states or states from people? And I pretty much think the former is where we need to be focusing our attention.
Great, thank you very much. Fu, you want to make some comments on this question?
Yes, with regard to the question on the process at third committee, I think that it will be a good opportunity for developing country or countries outside Budapest Convention to join the discussion. And I think countries like Vietnam would look at what have the experience with the Budapest Convention as a very positive guideline to how we should structure the new convention or the new instrument. I think the negotiation at the UN would be lengthy, and it would be a structured process. We may have to pass the first hurdles on procedural matters. Who should chair the process? Who should report it? And how we divide the jobs among so many vice chairs, and how we approach the new convention, whether we should work on a consensus basis or not, as Cathrin mentioned. But I think it's a good opportunity. I mean, because the Budapest Convention was created 20 years ago, at the time when cyberspace was something much different. And after 20 years now, we have much more people on Earth connected to the internet, and so that would have much wider ramifications. We have to also think about the future generation, how they use the internet and how they could be protected, as Duncan mentioned. And the state, I think I think the digital transformation will affect state also. I mean, how we exercise our rights and what we see with election voting in many countries, and I think there will be more engagement from internet, the normal people in how the state is run, and that will lead to, hopefully lead to a peaceful cyberspace.
Okay, thank you very much. We are now running a bit out of time, so what I propose is we'll take 1 minute per speaker if you want to have a last reaction. so please stick to 1 minute. I will go in the order of the discussion. So Mike, you will be first.
I think we need to be very careful about this treaty discussion. I agree with Duncan that a treaty may be appropriate, but what we need to do first is map what the existing law is, because if you're going to start a journey and you don't know where you are when you start, it's going to take a long time for you to get to your objective unless you're just darn lucky. And the problem is, I've been watching this area for now 20, 25 years, and folks are saying we need a new treaty. And my response is, but there's already a law on this. When we were working at the CCD COE, we had people telling us we need a treaty to prevent cyber operations against individuals and cyber infrastructure. To which I replied, we have customary law on that. And oh, by the way, there's a treaty called Additional Protocol 1 that deals directly with this point. So I agree that maybe a treaty is needed, but you cannot start a treaty process unless you carefully map out what the existing law is, so you can identify the lacuna, and so your effort can have some distinctive vector.
Okay. Tanya, you want to add something? Yeah.
Apologies. Just a short comment about the gaps in international law, whatever they may be. I think it links also to the knowledge gap, and maybe the development of international law links to exactly how different groups concerned talk to each other. So bridging this gap between academia, practitioners, state officials, and so on and so forth. This should be also an objective. So national administrations should talk. Should involve academics more. Academics should be more willing, maybe, to go into practice, into public administration or something of this kind. And this might also help the debate on the development of international law.
Okay. Thank you. Duncan?
So, actually, I can't agree anymore with Mike's point. I think the reality is we need to know more where we are. That's kind of what motivated the OAS project, which is to try and figure out beyond, the core high capacity states, what other states understand international law is. My comment about the treaty, or the idea of the treaty, is we seem the politics may be running ahead of where the lawyers want to be. And I'm just worried that we have these kind of two poles where one side refuses to discuss any treaty, and sometimes for quite good reasons. And then there's this push to have this kind of treaty that's focused on controlling content and protecting states from, legitimate harmful cyber behavior, but maybe some things that maybe we don't want states to regulate. And I think there's a third way that the conversation might proceed, and that we need to take seriously a narrative where we think about, like, how could we make or codify international law in ways that, make states understand more where existing international law operates, and make sure that it provides more stability and security for people rather than just states themselves.
Fu, you want to make a comment?
Yes, I see the positive side of the UN process, and I think that because at the very beginning, some mentioned that we don't have enough states making statement about what they think about cyberspace. I think the UN process is the unique opportunity for sovereign state to express their view on rules governing cyberspace. And from that, I think whether we could go 1 inch beyond the abstract statement that international applies, it depends on whether we could have consensus on that. But it's a good opportunity for state to express what they think. Another point is I'm curious about how we would engage private companies in that process. Otherwise, I think it would not be very effective in reality.
Okay, and we will finish with Cathrin. I wanted to ask you something actually for your closing remarks, and if you have any comments after all this discussion about the treaties and all this question on the universality of the Budapest Conventions and the way it's actually becoming like a bigger text than it was.
Yeah, thank you. Actually, François, that's a key point, because as I was trying to say in my in the initial part of my remarks, cyber-enabled crime has gone far beyond cybercrime. So the Budapest Convention in many ways has become a much more important instrument than it was when the negotiations started, and it has had 20 years to prove its value. I mean, Mike and Duncan have already said many things I agree with. The Budapest Convention started out as a regional instrument, but it now brings together many parties from all parts of the globe. Just to cite a few, we have Peru, Argentina, Canada, Japan, the Philippines, Nigeria, Senegal, Mexico, Morocco, the US, and Australia, who were all parties to the Budapest Convention. So we could definitely think about what else may be needed, but as Duncan was already highlighting, perhaps it's not on cybercrime. I think the idea of negotiating a new convention is always extremely tempting because every state imagines that that's exactly where they're going to place all of their ideas of how international cooperation should work and what international law should do. But the reality is often very far from that. And so I agree that before we start detailing what a new convention, a better, shinier, brilliant convention should do instead of the Budapest Convention, we need to take a very careful look at what has worked already and really what else is needed, and whether the way forward would not be to focus elsewhere when it comes to harmonizing state behavior in cyberspace.
Thank you very much. Thank you very much to all. So I will ask the audience to join me in thanking you for your presentation, for your thought, and for this discussion. I think it was very, very interesting, and it gave a lot of different perspective on this question of how to close the gap in international law. The video of the recording of this presentation and this roundtable will be available shortly this afternoon. This afternoon, you have two panel sessions, one on cyber and digital policies on good practice, and the other one on democracy in the digital age. And tomorrow at the exact same time, you will have an exciting roundtable on closing the accountability gap. Thank you very much to all, and have a good afternoon.